I have a kinship. I knew there was something good about just sitting next to you, that openness, friendly Midwest part of us. So thank you. Our speaker tonight about cancer and the law is with Cancer Legal Resource Center. Anya Prince is a recipient of the 2010 Skadden Fellowship to work at Cancer Legal Resource Center. And in the position she now has, she heads efforts to understand communities to provide education about legal rights surrounding genetic testing, legal resources, and those experiencing discrimination associated with genetic testing. So a real specialty niche. She grew up in LA and graduated from UCLA and went on to law school at Georgetown. Very impressive too. And let's see, she interned at a variety of nonprofits. I'm always impressed when people with professional backgrounds choose to work in nonprofits, because it's really important that all of us give back. And I think that's something that's Sarah talked about too, is that being inspired by the experiences you have creates in you a mission to do something different with your life when you're affected by cancer. I see it time and time again, even if it means just going back to work. Those kind of challenges are really important. And healthcare issues, as Anya will talk about, and the changing in healthcare environment, really complex stuff. So I appreciate so much that you came, and don't forget to use your questionnaire, your blank card, and you can actually do the evaluation as you go along. You don't have to wait to the last minute. So Anya, thank you very much.
Set up my slides. All right. Well, thank you very much for having me tonight. It's a pleasure to be here. I always like traveling and talking in front of people. We do a lot over the phone, so it's always nice to see real live faces. So thanks so much. So my name is Anya, and as Tom mentioned, I'm a Skadden Fellow at the Cancer Legal Resource Center, so effectively I'm one of the staff attorneys, and I do my work in genetic discrimination, but I work with all of the any callers that we have coming in, so I won't talk too much about genetics today, even though I love doing that. Okay, so our organization, Cancer Legal Resource Center, our mission is to provide free legal resources and information to cancer patients, survivors, caregivers, healthcare professionals, basically anybody who has some legal questions about coping with cancer. So our organization was founded in 1997, and it's a joint project of the Disability Rights Legal Center and Loyola Law School. So we're housed on Loyola Law School's campus. All of our services are free and confidential, and we have services in English and Spanish, although we can use language lines for any caller who calls in. We can use interpretive services. And what we have, I'm sorry, we have this thing showing up on the side. I don't know how to get rid of that, but we have an education model, not a litigation model. So what this means is we ourselves don't represent callers, and we don't give legal advice. And part of that reason is because we're a national organization, so we have people calling us from all over the country, and our attorneys are only barred in a few states, so we actually can't give legal advice in states that we're not barred in. But we do find the reason we have an education model is that we find that so often with a cancer diagnosis, litigation is not necessarily the answer. Litigation can take a really long time, and sometimes just knowing your rights and knowing the resources out there is half the battle. So what we do is we give information about the laws and help callers to understand sort of the buffet of laws out there and what might apply to them. And I'll talk a little bit about how we do this. So we have a national telephone assistance line. In 2011, we served a little over 4,000 callers through this line, and we have 4 attorneys who run it. So we keep ourselves busy. A lot of our calls, about 40% of our calls, come from California, but as I said, we're a national program. We also take information by email, letter, faxes, online intake, paper airplanes. However you want to get a hold of us, we will help you out. We also have a lot of resources online. So if you have questions about my presentation, you can always give us a call afterwards, and you can also go online to see what our resources are if you're the type of person who reads learns better by reading than hearing. One of the main resources that we have is the HCP manual, which is our healthcare professional manual. This is a free download online. It says it's for healthcare professionals, but there's absolutely no reason that a patient or a survivor can't read it. It's not going to lock you out of it. And it has really great resources about everything I'm going to talk about today. We also have teleconferences and webinars that are on our events page, and those will take the topics that I'm talking about today and break them out into hour-long blocks. So I'm going to talk for an hour about 5 subjects that we generally do an hour for each of those subjects. So I'm going to throw a lot of information at you, and if you want to sort of listen to it again in a slower pace, then that's a great resource. So I mentioned that we ourselves don't litigate. But sometimes, unfortunately, litigation is what's needed if there's been employment discrimination or there's an insurance appeal that needs an attorney. So what we have is a professional panel of attorneys who have all agreed to give our callers 30-minute free consultations. Many of them do agree then to do some sort of reduced fee or pro bono service after that, but that's sort of negotiated out. So if we find that there's an issue that needs an attorney's help, then we try to match you up with an attorney, and especially in the LA and Orange County area, we have a lot of attorneys, so we try to match you up with an attorney who works in the area that you're having legal questions about. We also have free cancer rights conferences. These are day-long cancer rights conferences that essentially take all the information I'm giving you today over 8 hours. So again, I'm going to show you how much we're fitting in today. But we have one coming up in Boston this month, and then Chicago, and we'll also be up in Fresno next October. Fresno is probably the easiest to get to if you want to go there, but if you happen to be in the other states, you're welcome to come along. So as I mentioned, our mission is to provide free legal information about cancer-related legal issues. So one of the first questions we always get is, what's legal about cancer? And a lot is legal about cancer. So these are just some of the topics that we get calls about on a daily basis. Health insurance, employment, disability insurance, and government benefits are our main categories, as well as financial assistance or treatment assistance, although financial assistance and treatment assistance is usually stemming from problems with health insurance, employment, or disability insurance. And so they kind of all go together. And I think one of the resources that we really can give is looking at a question that somebody asks, not just as a, sometimes people say, I think I've been discriminated based on my employment, which may or may not be true, but what we can offer is a greater look at it of, okay, well now you might not have employment, but what else can we do? How do you keep health insurance? How do you get disability insurance? And really looking at not just the narrow question, but all of the resources available. So those are some of the topics that we help callers with. So first I'm going to talk about employment protections today. So there are many federal and state laws that protect and promote employment of cancer patients, survivors, and caregivers. The number one thing to remember in this area is that these federal and state laws that I'm going to talk about are just the baseline protections that employers have to give. But many employers offer more protections than they have to. So it's really important to look at your employee manual, dust it off from the drawer that you hid it in when you first came. I know mine's somewhere deep down in my drawer. Or if you're part of a union organization, talk to union representatives, look at employee contracts, go in and speak to the HR representatives, because there may be more that the employer is offering, and if they've put it in that employee manual, then that's what they're contractually obligated to do beyond what I'm going to talk about. So just keep that in mind as I'm speaking, that these are just the baseline protections that I'm going to be talking about. So first, I'm going to talk about the Americans with Disabilities Act, or the ADA. So the ADA is a law that was established to protect people with disabilities from discrimination. So it applies to all phases of employment. And what this means is it applies to hiring, firing, the terms and conditions of employment, how much you're paid, raises, everything from start to finish in a job. It's enforced by the EEOC, or the Equal Employment Opportunity Commission. And so if you feel that you have been discriminated against, that's the organization that you have to go through an administrative process before you could sue in court. So there's very specific steps, and we'd be happy to talk with anybody about those steps if you give our organization a call. So the ADA applies to private employers with 15 or more employees, or to state and local governments. It does not apply to federal governments. So if you work for a federal agency, there's different rules that apply. There is a law that's very similar to the ADA, but it's a different process to file complaints. In order to be, so with the federal employees, a lot of what I talk about with the ADA will apply because the laws mirror each other. But you just want to make sure you are following the right one. So in order to fall under the ADA's protections, an individual must be a qualified individual, and they have to have a disability. So in order to be a qualified individual, they have to be somebody who can perform the essential functions of the job with or without a reasonable accommodation. Now I'm going to talk about what a reasonable accommodation is in a little bit, but essentially this means that if I'm applying for a nursing position, I'm going to have a nursing license. I can't say, oh, they didn't hire me because of a disability, and they say, no, we didn't hire you because you didn't have the qualifications. So that's essentially what it means to be a qualified individual. Now, to have a disability, you have to fall under this definition, which is a physical or mental impairment that substantially limits a major life activity. So there's those three parts to it. Cancer can be a disability under the ADA, but what's most important to remember is it's an individualized assessment. They're going to look at how the cancer and the cancer treatments affect you as an individual to consider whether you're disabled. So it has to substantially limit a major life activity. So what's a major life activity? It can be walking, talking, breathing, eating, caring for yourself, just the activities of daily life. And then in 2008, there were amendments to the ADA that Congress passed that added concentrating, thinking, communicating, sleeping, and operation of major bodily functions to the list. And these last ones really help cancer patients to fall under the protections of this law. Oftentimes when going through chemotherapy, people might experience chemo brain. And so you might be having trouble concentrating, thinking, or communicating through that. And if that substantially is limited, then that can be a disability under the ADA. So when you're looking at whether you fall under the ADA, you look not just at how the cancer itself is affecting you, but also how the treatments are affecting you. Now, there's three ways to fall under the protections of the ADA. The first is if you have a physical or mental impairment that substantially limits. So if you currently have that impairment, then you are disabled under the law. You also are protected if you have a history of a physical or mental impairment. So somebody who is in remission from cancer cannot be discriminated against based on that history of having a disability in the past. And additionally, a really important protection for cancer patients is you can't be discriminated against for being regarded as having an impairment. So let's say you have a cancer diagnosis, but it's not affecting you yet. You know, maybe the treatments aren't affecting you, or maybe it was caught so early on that the cancer itself isn't affecting you yet. And you inform your employer that you have a cancer diagnosis, and they all of a sudden assume that you can't do the work that you did before. They may be regarding you as having a disability, even if you don't have one. And that's illegal under the ADA. And then finally, there is protection for caregivers. So there's a protection for if a person is associated with an individual with a disability. Now, this doesn't give protection to show up to late work or to take time off work, and we'll talk about taking time off work in a little bit. But we have seen some situations where just by the fact that you're caring for somebody, or perhaps if somebody's on your health insurance, an employer starts treating you differently. And so that is also protected under the ADA. So those are the 3 ways to fall under. And if you have a disability under the law, you're 1, protected against discrimination, and you also are entitled to what's called a reasonable accommodation. So a reasonable accommodation is a change or modification of the workplace that allows an individual with a disability to perform the functions of the job. So this can be something as simple as, I have to file documents for my job. I have a hard time bending over. My file cabinet is down here. My coworkers is up here. Let's just switch them. So that can be a very easy solution that helps somebody with a disability to perform their job more easily. It can range from that to job restructuring. It can be, I'm going to work from home a couple days a week. I'm going to work on a flexible time schedule so that I work 10 hours a day, Monday through Thursday, and then on Friday I go and get my chemotherapy. So it's a broad range of options, and it depends on the employee, the employee's job, their limitations, and who the employer is. Because the flip side of reasonable accommodation is that it cannot be an undue burden on the employer. And what undue burden means is money. It can't cost the employer too much. So if there is a 20-person small business and somebody needs an elevator put into the office building for an individual with a wheelchair, that's probably going to be an undue burden on the employer. And maybe if it's a small business, working from home might be an undue burden because it's going to be hard to restructure who does what job. But if it's a really large company, more of those options might be available. The most important thing with the reasonable accommodation process is that it has to be an interactive process with the employer. So the employer can't just say, no, that's an undue hardship for us, we're not going to let you work from home. They have to say, well, it's going to be an undue hardship for us to let you work from home, but how about we give you more rest breaks during the day, or how about we do this? And they have to work with you to come up with a solution. California also has a law called the Fair Employment and Housing Act, and this is very similar to the ADA, except that it applies to employers with 5 or more employees, so it covers some of those small businesses. And also the definition of disability is broader, in that instead of having to substantially limit a major life activity, it just has to limit a major life activity. Now there's some nuances in that, but the most important thing to remember is that it's a broader definition, so you may be able to fall under FEHA before you fall under the ADA. So next I'm going to talk about the Family and Medical Leave Act. This gives individuals, it's a federal right to take time off work. And it gives 12 weeks of job and health benefit protected leave per year to take care of yourself or a spouse, parent, or child. So there's a couple really important things in that. First, it's job and health insurance protected, but unpaid. So it allows you to take 12 weeks off, but it doesn't guarantee that you're paid. So this is one of those times to look at your employee manual to see what your employer offers. It's also health benefit protected. This means that your employer has to maintain your health benefits while you're on that leave. What it doesn't mean is they don't have to, sorry, that was some double negatives. They do not have to maintain disability insurance, life insurance, any of the vision, dental, whatever other benefits they offer, the employer is not legally required to keep. Oftentimes they do because it's such an administrative hassle to sort of take somebody off the program and put them back on, but they're not required to, so it's something important to check. And the law really is quite narrow, so you can take time off to care for yourself if you have a serious medical condition, or to care for your spouse, parent, or child. And it's actually just a minor child. So this is always the point in the presentation when I say, well, my parents can't take time off to take care of me because I'm not a minor child anymore. So I either need to get married or have a kid so that somebody can take FMLA to take care of me. And the other thing is a federal definition of spouse, so it does not include domestic partnerships, although there is a California law that covers domestic partnerships and allows domestic partners to take 12 weeks off. FMLA time can be taken all at once or intermittently, which means you can take 12 weeks all in one go, or you could take every Friday off or every Thursday and Friday off for chemotherapy until it adds up to 12 weeks worth. So the employers that have to comply with FMLA are all public employers and private employers with 50 or more employees within a 75-mile radius. So think like a bank might have only 25 employees in one place, but within the 75 miles, they can get up to 50. To be qualified as an employee under FMLA, you have to have worked for your organization for 12 months and worked 1,250 hours in the last 12 months. So this ends up being approximately 12 or 24 hours a week, so a little bit over part-time. So at the end of 12 weeks, let's say you take FMLA all at once, at the end of 12 weeks, the employer is not required, if the employee is unable to come back to work, the employer is not required to keep the job open anymore, so they are allowed to terminate the employment after 12 weeks. However, you may be able to ask for a reasonable accommodation under the ADA to extend your FMLA time. Now this is, again, cannot be an undue burden on the employer, and so what courts have held is that if it's a definitive end to the time off that you need, it may be reasonable. So if I say, I just took 12 weeks off, my doctors say that it'll be 2 more weeks and then I'm ready to go. Because it's a definitive end and it's not too long of a time period, that may be a reasonable accommodation for the employer to give you that time. So that's always something that's worth asking at the end of an FMLA time. So what I want to mention really quickly when we're talking about FMLA is this is for caregivers. California is one of the only states to offer temporary disability insurance for caregivers. So under the SDI system, which I'll talk about in a little bit, somebody who is taking time off to care for their child, spouse, or parent or domestic partner can get 6 weeks of paid time off. It won't cover your entire salary, but it covers a portion of it. And it would be 6 weeks of leave per any 12 months. So there's a little bit more information about that. So here are just some resources available, and I think we'll have copies of the slides. They'll be posted online, or the video will be, so you can always come back to these in the end or call up our organization. So in general, FMLA gives you the job protection when you're taking time off work. Now I'm going to talk about disability insurance, which replaces the wages if you take time off work. So there's a number of different disability insurance programs available. First, you always want to check if your employer or through any other program, if you have a short-term or long-term private disability insurance program. We've had some callers who don't realize that their employers offer these programs because, you know, you're starting your job and you get this many pages to sign, and in page this, there's something about disability insurance, and when you were signing that, you thought, I won't need this, and so you don't remember it. But it is always important to check and see what they have, or sometimes you can get them individually, but they can deny for pre-existing conditions, so you have to have gotten the disability insurance prior to needing it. But there's also some associations, if you're part of a professional association, that offer them. There's also state short-term disability insurance and federal, and I'll talk about those now. That was a little bit, I covered that. Okay, so California is also one of 5 states and Puerto Rico that offers a state disability insurance program. And this is a state-run short-term disability insurance. It lasts from 8 days to up to 1 year and pays 55% of your wages while you're off work. The requirements are that you have to have had a loss of wages, so if you're taking sick time or vacation time, it wouldn't count. You have to have been unable to work for at least 8 calendar days, and you have to file a claim within 49 days of the disability began. But most importantly, you have to have earned at least $300 from which SDI taxes were withheld. So it's essentially a taxation system similar to the Social Security retirement system. So if you look at your paycheck and you see that SDI withholding in the state section, that's what this program is. And this is the same program that covers the family temporary disability insurance that I just spoke about. So for both of those programs, you have to have paid those taxes to use the benefit. Now, it doesn't provide job protection, so that's where the FMLA comes in, or continuation of health benefits. And one big exception is if you don't pay into the tax system, then your employer doesn't have to pay into the tax system necessarily if they've opted out. And one big category is teachers. They have their own. California Public School Teachers has a completely different system called CalPERS. So there's also federal disability insurance benefits, and these are long-term disability insurances. And so there's two programs that the Social Security Administration runs: the Social Security Disability Insurance, or SSDI, and Supplemental Security Income, or SSI. So we have state disability insurance, SSDI, and SSI. So it's an extremely confusing situation because all the acronyms sound the same, and they're similar programs but have slightly different things. So this is one of the great times to go online and read through our healthcare professional manual on this and just read it over and over again until it sticks which one's which, because I understand that a lot of what I'm saying sounds like gobbledygook when I'm throwing out these acronyms. So these two programs are the long-term ones, and they're similar in that they use the same definition of disability. So the definition is if you have a medically determinable physical or mental impairment that stops you from doing substantial gainful activity, i.e. you're not able to work anymore. And it's expected to last a year or result in death. And what's most important about that is it's the expectation that your disability will last a year. So you don't have to wait until you've been disabled for a year to apply to this program. You just can apply as soon as your doctors say, this treatment protocol will probably take a year and you might not be able to work that whole year. So those are what the two have in common. How they're different, and I apologize, I don't think I have the slide on this, but I'll talk through it. SSDI is based on work history. So in order to be eligible for SSDI, you have to have paid into the Social Security retirement system. It's kind of like taking early retirement, except that it does not affect your retirement benefits at all. But it's a similar system. Once you've been on SSDI for 2 years, you'll be eligible for Medicare, which is the health insurance program for older adults. And so that's why it's the retirement system model that I think about. So generally, you have to have worked 5 out of the last 10 years to be eligible for SSDI. Additionally, you cannot take your retirement and SSDI at the same time because they're essentially the same pool of money that you're working from. So it's just going through the Social Security retirement system. SSI, or Supplemental Security Income, uses that same definition of disability, and its second requirement is that you have limited income and assets. So the income level varies on how many people are in your household, what county you live in, but the asset levels generally across the country are about $2,000 for an individual and $3,000 for a couple. And this includes savings accounts, checkings accounts, retirement savings programs, so IRAs and 401ks are counted. One home and one car are exempt from the calculation, but everything else is counted. And one thing that's tricky about SSI that is counted is any support you get for food and housing. So if you're living with a parent or you're living with somebody else, and so they're not charging you rent, but that actually can count as income because you're essentially not paying anything out. So it's a tough standard, but that is available. And in California, if you're eligible for SSI, you're automatically enrolled into Medi-Cal, which I'll talk about in a little bit, which is the state Medicaid program. So again, SSDI is based on work credits and is paired with Medicare. SSI is based on income and assets and is paired with Medicaid. And SDI is the short-term state one. So give us a call if you want us to talk through that and how it applies to you, because I understand it's, I wish they could have named them like hop, skip, and jump or something so that you could tell them apart, but they're not too creative, those legislators. So that's employment. And I apologize for going too quickly, but we do have a lot to cover, and feel free to write your question cards and I can go back over anything. So I covered taking time off work, job protections for individuals with disabilities, and then some of the disability insurance programs that help to replace wages if you're unable to work. So now I'm going to switch over and talk about health insurance. So first I'm going to talk about some health insurance options. Then I'm going to talk a little bit about healthcare reform and what that is doing to change how health insurance works and some of the options available. So these are just a few of the options available, and I will go through them, but to give you an idea of what all is out there. So the first scenario that I'm going to talk about is if you get your health insurance through work, which many individuals in America do. So if you have health insurance through your employer and you're unable to work, or you no longer work at the organization and you lose that health insurance, then you may be eligible for Cobra. So Cobra allows an individual to keep the exact same health insurance that they were on while they were employed, but the trick is that they have to then pay all the premiums. So you have to pay the premiums you were paying from your paycheck before, as well as the proportion your employer was paying. Plus, as a kicker, they can add a 2% administrative fee cost, so you can end up paying 102% of the premium. So it can be very, very expensive, especially in a time when you're presumably no longer working. But the positive of it is that if you're going through treatments, you know that you have the exact same doctors and that they're covered by your insurance, and you can keep that continuity of care. It applies to employers with 20 or more employees, and it generally lasts for 18 months for individuals and 36 months for dependents. There's different qualifying events that happen. The first is termination of employment or reduction in hours. So this can either be willful or unwillful termination. So I can quit the job and be eligible for Cobra, or I can be fired and be eligible for Cobra. And with that, you get 18 months. But there's other conditions like if I have dependents on my health insurance plan, and if I retired, went on to Medicare, if I passed away, if there was a divorce or legal separation, all my dependents would be eligible for 36 months of Cobra. Or the last qualifying event is aging out of your parent's plan. So once a child, for lack of a better word, turns 26 and they age out of their parent's plan, they could be eligible for Cobra for another 36 months after that. One way to help lower the cost of Cobra is through the Health Insurance Premium Payment Program, or HIP. I don't know where the last P in the acronym went, but it's just 2 P's in the acronym and 3 in the title. So HIP is a California program. It's state by state, but California does have one of the programs. And if you're eligible for Medicaid or Medi-Cal in California, the HIP program will actually pay your private insurance premiums for you. And if you think about it, this makes sense from the state's perspective, because they could either pay all of your health care costs through Medicaid, or they can pay your insurance premiums to keep you on the private plan and have the private plan cover your health care costs. So it's a good program to consider if your other option is to go on to Medicaid, or if you have limited resources after no longer working. Additionally, California has a state law called CalCobra, and this is very similar to Cobra, but it applies with employers with 2 to 19 employees. So Cobra was 20 or more employees, so CalCobra helps to cover those small businesses. Additionally, If you work for an employer with 20 or more employees and you get 18 months of Cobra, CalCobra will extend that for up to 36 months. So you can actually have 36 months of Cobra coverage, half through Cobra, half through CalCobra. Unfortunately, though, CalCobra can have 110% of the premiums, so they can add 10% to the premium cost for administrative fee rather than the 2% of Cobra. So it can get even more expensive at the end of that 18 months. So let's say that you go through Cobra and you want to make sure you have that continuity of care. So you get to your end of your 36 months after going through Cobra and CalCobra. Now what? You have a pre-existing condition, so it might be difficult to get insurance on the private market. So after Cobra ends, a law called HIPAA can help out. So HIPAA is the Health Insurance Portability and Accountability Act, and you've probably all heard of HIPAA in terms of health insurance privacy. So that's the law that stops your doctors from just yelling out your diagnosis to the world, but I'm not going to talk about the privacy part, but I'm going to talk about the portability part, which gave some really important protections that often aren't talked about. So HIPAA prohibits discrimination against individuals based on a pre-existing condition when going from a group health insurance plan to a group health insurance plan, or from a group plan to what's called a HIPAA individual plan. And I'm going to talk about what that is in a second. But the number one thing to keep in mind when we're talking about HIPAA is that you cannot have a break in coverage, in health insurance coverage, for more than 63 days. The end of 63 days, you lose all HIPAA protections. So you always want to make sure that you keep health insurance no more of a gap than 63 days. So the first thing that HIPAA does in the context of health insurance is it guarantees individuals who are going from a group plan to an individual plan, it guarantees them a right to health insurance in every state. And in California, there's 7 or 8 HIPAA individual plans in every state. The tricky thing is that these are individual plans run by private insurers. And so if you call up a private insurance company and say, I just finished my Cobra, I have a cancer diagnosis, I want health insurance, they'll say, most likely, I'm sorry, you have a pre-existing condition, we're not going to insure you. If you call up that exact same representative at that exact same insurance company and you say, I just exhausted Cobra, I've had a cancer diagnosis in the past, and I want a HIPAA individual insurance plan, they'll say, yes, come on in, we have to insure you. So it's unfortunately one of those laws where there's not a requirement for there to be notice about it. Cobra has very specific notice requirements written in the law. HIPAA does not. So you actually have to know the magic password, which is HIPAA, to get this plan. And there's, again, 7 or 8 options in the Southern California area. The requirements for these plans are that you exhaust Cobra or your state Cobra plan, so it means you've gone all the way through. And so this is the hard part, is if you can't pay your Cobra premiums and you lose Cobra because of failure to pay the premiums, you have not exhausted Cobra, and so you've lost your right to HIPAA. So that's one of the reasons where even though Cobra is really expensive and really hard, keeping that all the way through can be very important to be able to get health insurance in the future. But if you lose Cobra, don't worry, I'll talk about other options in the future. There's still hope. You also have to be ineligible for other group coverage through a different employer, through Medicare or Medicaid. And again, you have to apply no later than 63 days. So we have a list of the options. If you are thinking about these, give us a call. We can show you the options. It's unlike Cobra in that you're not keeping the same exact insurance plan, so you're shopping for new insurance. So you really want to look at all 7 or 8 plans, see what they offer, see what benefits they cover, see what prescription drugs they cover, to see what's best for you. The second thing HIPAA did is to limit what's called a pre-existing condition exclusion period. So I'm going to give what sounds like bad news first, and then I'm going to give what sounds like good news and actually is good news second. So this is important both in the context of going from a group plan to a HIPAA individual plan, but also when going from a group plan to group plan. So if you're switching employers and having different insurances, this is an important part of the law to keep in mind. So in general, a group health insurance plan cannot deny somebody based on a pre-existing condition, unlike on the individual market. However, they are allowed to impose a pre-existing condition exclusion plan, or period, which means that for a period of time, they'll cover your insurance if you break your arm, if you get a cold, anything else, but they won't cover you for your pre-existing conditions. So if your pre-existing condition is cancer, they won't cover screenings, they won't cover chemotherapy or anything like that. Now HIPAA, prior to HIPAA, the industry standard was actually 2 years, and HIPAA limited this to 1 year. So they actually did good, although it sounds like an awful part of the law. And in California, our state law limits it to 6 months. So the max you can have in California, depending on your insurance policy, is 6 months. But the third thing that HIPAA did was it gives creditable coverage for past insurance. So it gives you credit for the time that you've had insurance in the past, as long as there hasn't been a gap for more than 63 days. So what that means, let me just go to the example. So let's say I had a job for 4 months, didn't like the job and moved to a different one, but I had health insurance through that other employer. And now I'm switching to a new insurance company, and I've had a gap in coverage of, let's say, 30 days. The new insurance company says, we want to impose a 6-month pre-existing condition exclusion period on you. And I say, no, wait, I've had health insurance for the past 4 months. So I show them that I've had health insurance for the past 4 months, and that is subtracted, so all I have left is 2 months of pre-existing condition exclusion period. So what that means is if you've had health insurance for at least the past year with no gap in coverage of more than 63 days, you cannot have a pre-existing condition exclusion period imposed on you because you can wipe it out with the past coverage. And this doesn't matter if you've switched insurance companies every 2 weeks, as long as there hasn't been a gap, you can add them all together and wipe out any pre-existing condition exclusion period. Now we tell this because my previous director of my organization was applying for a group plan. The plan imposed a pre-existing condition exclusion period on her, and she said, wait a second, I had an individual health insurance policy with you guys for the past year. And they said, well, send us a certificate of credible coverage. So she had to call up this representative of the insurance company, get a certificate, and then send it to this representative of the same insurance company to show that she didn't need an exclusion period. So while the law has these protections, you have to know about them, unfortunately. So that's why it sounds like it's pointless to talk about this part of the law, but it does happen, and you just have to know if there's an exclusion period, think, wait a second, I might be able to narrow that down a little bit. So that was the continuum of I have insurance through my employer, so then I'm going to go on Cobra, and then I'm going to go on to HIPAA. So what do you do if you're not in that continuum? If you've had a gap in your coverage, or you don't have health insurance through work, what are your options? One of the first options is the Major Risk Medical Insurance Plan, which is by far my favorite acronym of this entire presentation, Mr. MIP. You gotta get some excitement from SSDI and SSI and Mr. MIP. So Mr. MIP is a health insurance plan for individuals with pre-existing conditions. So it's a high-risk health insurance plan for these individuals. In order to be eligible, you have to be ineligible for Cobra, CalCobra, Medicare, Medi-Cal, HIPAA. And there's 2 different options, an HMO and a PPO. And the cost of the program depends on your age, where you live. And unfortunately, the kicker is that the PPO can have a pre-existing condition exclusion period for 3 months. So even though it's a health insurance plan specifically designed to cover individuals with pre-existing conditions, they impose a 3-month pre-existing condition exclusion period. But at least it's health insurance, and once you get past the 3 months, you can be covered. And the HMO has a 3-month waiting period. So either way, there's sort of a, which one's, Once you're on, so there is a maximum enrollment on Mr. MIP, which is why there's a waiting period. But once you've been on Mr. MIP for 36 months, you move to what's called a Mr. MIP graduated plan, and then somebody else can come into the spot. So there is a lot of turnover and availability for this plan. So this is California's version, and other states have other versions in case you have family or friends in other states that might need something like this. So we have all that information, and you can give our telephone line a call. Another option for individuals with low or no income are state and county programs. You always want to make sure you check that, or sometimes there's charity care or ability to pay care at hospitals. There also was a law passed by Congress in the 40s, I believe, that's called Hill-Burton. And this is a law that was passed that gave hospitals money for modernization and construction of their facilities, and in return, they agreed to give free or low-cost care to patients in their area. So you can go to this website or call the number to see where there's a Hill-Burton facility near you. And unfortunately, I don't know the ones around here off the top of my head, for all I know. Sorry. Okay, so those are some of the options out there prior to healthcare reform. There's also Medicaid and Medicare, which I now can't remember if I have at the end of the presentation in the slides, but if I don't, feel free to ask me questions about those if you have any at the end. So now I'm going to briefly talk about the Patient Protection and Affordable Care Act, otherwise known as healthcare reform. So healthcare reform was passed in March 23rd, 2010, and as Tom mentioned, this entire portion of the presentation may become moot in a couple months. So the Supreme Court has heard challenges of the constitutionality of this law. So I'm going to present it as if they say everything's constitutional, but I'm happy to talk at the end about sort of what they're looking at. There's different things that they're, specific things that they're looking about the constitutionality of. But one of the portions that the Supreme Court is looking at is whether or not they can separate out, if they find the most controversial part, which is the individual mandate, and I'll talk about that. If they find that unconstitutional, one of the questions they're looking at is what happens to the rest of the law. So there's a chance that they may say, this portion and this portion of the law is unconstitutional, but the rest is fine. So chances are either none of my presentation will be a moot point, or only some of it will be a moot point. So I'm not going through this exercise just for the fun of it. So the one thing that the ACA sort of had two main parts. One was to expand coverage options, and the other was to change how insurance companies work. So one of the new health insurance options is the Pre-Existing Condition Insurance Plan, or PSIP. Now this is very similar to the state high-risk pool. And it's an insurance plan for individuals with pre-existing conditions. In order to be eligible for this plan, you have to be a U.S. citizen or lawfully present in the U.S., have a pre-existing condition, and have not had insurance for the past 6 months. So if you haven't been insured for 6 months, this is a good option. And it's actually one of the only programs in this recession that is well-funded and underutilized. They actually are trying to get people into this plan. You might have seen billboards around town. So if you know anybody with any pre-existing condition, not just cancer, tell them about this plan, because they're actually lowering the premiums every 6 months or so to try to get more and more people in. In California, this is run by the same board that runs the Mr. MIP program. So you might actually be eligible for both the state plan and the federal plan, and then you just want to look at the differences, see what it covers, see what the co-pays are, to see what's best for you. Another important fact that I didn't say on the Mr. MIP slide was that actually for the state program, you do not have to be a U.S. citizen or lawfully present. You just have to be a California resident. So if you or anybody else you know is undocumented and needs health insurance, that is an option in California for them. So one of the things that health care reform did was set up what's called the portal. And this is essentially just a website that gives lots and lots of information about healthcare reform. So it's www.healthcare.gov, and it really is a great user-friendly tool for information. But the part that I really want to mention is this explore your coverage and pricing options, that sort of box in the middle. So if you go to that and you pick your state, California, and you give a little bit of information about yourself, not anything personal or identifiable, but whether you're an individual with a medical condition, a pregnant woman, a senior, and you say a couple of different things about yourself. So, we tried to get health insurance and couldn't. I need health insurance for a different reason. How old am I? And then whether you're a veteran or have breast or cervical cancer or you're a dependent under 21. So you just check information like that. And it lists out all your possible health insurance options. And has the Learn More tabs, which will send you to the website of these. So it will list off Cobra, it will list off Mr. Mitt, it will list off, you can see the pre-existing condition insurance plan, a specific program through Medicaid for breast and cervical cancer treatments. So this is a really good way that if you are wondering, you say, oh, I remember Anya mentioned some plan that I thought might apply to me. This is a really good, easy check to see what insurance options might apply. The Finding Care You Can Afford will talk about Hilburton and charity care programs in your area as well. It's also available in Spanish. So that was one of the new insurance option that was created. And now I'm going to talk for a little bit about some health insurance reforms, so how private insurances do business and what changes were made. First, we want to talk about what policies have to comply. So this is private insurance policies. So private insurance policies issued prior to March 23rd, 2010 are considered what's called grandfathered plans. So they actually don't have to comply with all of the law. And I'll explain when they have to and when they don't. But what's important to keep in mind is it's for group insurance, it's not when you entered the plan, it's when your employer-sponsored plan began. So many, many group health insurance plans are grandfathered because the employer started the insurance prior to 2010. These will lose their grandfathered status if they make significant changes to their plan. So if they cut benefits or if they change the copay amount significantly. However, any policies issued on or after 323 have to comply with all of the laws that I'm going to talk about. It's also important to keep in mind that there's two different types of employer-sponsored health insurance. The first is what's called an insured plan, and this is what we normally think of as health insurance. The employer pays a premium to a health insurance company. The health insurance company pays the cost of care. But there's also what's called a self-insured plan or a self-funded plan. And this is one where actually the employer themselves pays the cost of health care. So if I break my arm and I work for a self-insured employer, the employer actually is going to pay the doctor whatever it costs to fix my arm. So they're paying all the costs. What's tricky about this is oftentimes they contract with a third-party administrator who is oftentimes an insurance company. So I might have an Aetna insurance card, but I actually have a self-funded plan, and Aetna is just helping to manage how I get the care, but my employer is actually paying for it. I had a hard time sort of understanding why an employer would do this, but I had a friend who works for the federal government and they have cars. They give cars out to some federal employees. And I learned that the federal government actually doesn't pay for car insurance for them. Because if you think about it, they have so many cars out there that it's actually going to be cheaper for them to just pay dent by dent and car by car than to pay or car insurance for the entire fleet. So it's kind of the same concept, but for health insurance, if that helps to understand why somebody would do it. So I just wanted to lay those out of the self-insured versus insured, and the grandfathered versus not when I'm talking about these reforms. So first, one of the changes is lifetime and annual limits. So prior to healthcare reform, insurance companies could establish lifetime and annual caps. So essentially, you had so much money that they would pay out, and if you reached that maximum, you effectively had no health insurance for the rest of the year or for the rest of the lifetime. And the annual limits sometimes were as low as $50,000, which when going through cancer, you can reach very quickly. So what healthcare reform did is it says that there are no lifetime limits, there can be no lifetime limits on essential health benefits. And this is already in effect now. So if you have a health insurance policy that says that it has lifetime limits in it, that portion of the contract is completely void. They cannot enforce that anymore. And this applies to grandfathered plans, and it applies to self-insured plans. They can have a cap on non-essential health benefits, but not on essential health benefits. So I guess like tanning salons or something, I don't know. Annual limits, the law treats a little bit differently. For now, annual limits are allowed on essential health benefits, but only until 2014. And what they did is they're slowly increasing the amount that the annual limit can be, or the minimum that the annual limit could be. So when the law was first passed, they raised the annual limit to $750,000. And then they raised it up to $1.25 million. And I think it might be at $1.25 or $1.75 million now. They are giving waivers to some health insurance companies who it would be a burden on them to all of a sudden raise their limits, their annual limits to $1.25 million. So you do want to check to see whether your plan is part of the waiver if they're saying that they have to give notice of that. So this applies to group grandfathered plans, but not to individual grandfathered plans, and it does apply to self-insured plans. Another area of change was rescissions. Prior to healthcare reform, what health insurance companies would sometimes do is they would give you your health insurance, and then once you started submitting requests for claims, they would go back to your original application and they would scour it. And they would find some mistake somewhere in the application and say, we're actually rescinding your entire insurance policy and you no longer have insurance. Forget that you've been paying the premiums on time for the past 2 years or whatever it was. We're just going to take that away from you. And they were allowed to do that. They got a lot of pushback from it, and there were some lawsuits in California on it. But that was a general industry practice. After healthcare reform, there are no rescissions of healthcare coverage allowed unless there's been fraud or intentional misrepresentation of material fact, which is fancy legal for you lied about it and you knew it, and it was a big deal. Also, plans have to give 30 days notice if they are going to rescind your policy so that you have some time to get other care. It applies to grandfathered plans, it applies to self-insured plans. Healthcare reform also changed preventive care. All health insurance plans must cover certain preventive care services, and they have to be completely free of cost. So you don't have to pay any deductibles, you don't have to pay any co-pays. You can, if you're using an in-network provider, you can be required to pay for, like if you're going to a doctor's visit and you're getting preventive services and another checkup, you can be required to pay the checkup part, but you can't be required to pay anything for the preventive services part. Unfortunately, this does not apply to grandfathered plans, so that's one area where if you have a group health insurance plan through your employer, you might not have this protection. But it does apply to self-insured plans. On healthcare.gov, there's a list of all the preventive services that are covered. They include mammographies over a certain age, they include colonoscopies, BRCA, genetic counseling, but they also include diabetes screenings and depression screening and obesity prevention screenings, and there's a whole host that are not just related to cancer. So it's worth taking a look and seeing if there's any of those that you want to go and do. Another area of expansion under the ACA is it expanded coverage for kids and young adults. So I use children broadly because I don't know what else to use, but a child can now be covered under their parents' plan up until the age of 26. So prior to healthcare reform, oftentimes once you turned 18, you could stay on your parents' plan as long as you were in school full-time, but that was sort of the only exception. And what was happening is students would get sick, lose their full-time student status because they were sick, and then no longer have health insurance because they got kicked off because they were no longer a full-time student. So now across the board, whether you're in school or not, a child is eligible on their parents' plan until age 26. And after that, they may be eligible for Cobra for 36 months. So this actually can give a continuum of care for somebody up until age 29, which really helps young adults in transition in jobs where they might not have a job that covers insurance. Additionally, one reform that already passed is that children with pre-existing conditions can no longer be denied health insurance based on a pre-existing condition. It applies to group grandfathered plans, but not individual grandfathered plans, and also applies to self-insured plans. There was a lot of pushback on this law amongst insurance companies. Unfortunately, some insurance companies in some states said, fine, we're just not going to cover children overall. And various states have had various ways of combating this. California passed a law that helps stop that practice, although it is escaping me exactly what they did, but if you have questions about it, I can look it up. But this is something that already went into effect September of 2010. So those were all reforms that have already gone into effect or are in the process of going into effect. But there are some long-term benefits of the law that I'll quickly mention. The biggest one, I think, by far, is that beginning January 1st, 2014, adults cannot be denied health insurance based on a pre-existing condition. Health insurance companies will no longer be able to consider any physical or mental condition at all, any health status, any medical history, any genetic information, or your gender or your age. They can't take any of that into account. They already can't take genetic information into account. Have to throw in that plug for genetics, but everything else is new. And one of the very significant thing is gender. Women overall pay more for health insurance than men do, even without maternity care. I don't know why. Then again, I think men overall pay more for car insurance, so the systems are unfair both ways. But this at least fixes the health insurance disparities. So they can't look at any of that anymore. And so if you apply, they can't ask for any of that. They just can look at where you live, and I'll tell you that in a second. The other thing that it establishes is now because people can shop for insurance without being denied based on a pre-existing condition, there's going to be a lot of people out there who want to go shopping for insurance. So each state is creating what's called a health insurance exchange. And this is generally a mall for insurance. And they're going to create a standardized format for showing what insurance options there are. So there's going to be a gold standard that's 90% covered and you pay 10% of the co-pays. Then there's an 80-20, a 70-30. So you can really compare the cost of the health insurances. And you can shop for it because now you can't be denied. Here's the big one that is the most controversial part of healthcare reform, is that beginning January 1st, 2014, all U.S. citizens and legal residents must have health insurance, although there's breaks in coverage are allowed for less than 3 months, and there's exemptions for religious objections. Now, the reason that they have this part of the law is that they can't require health insurance companies to cover individuals without looking at their pre-existing conditions, without having individuals have to have health insurance. Because otherwise what's going to happen is I'm just going to run around with no health insurance until I get sick, and then I'm going to go out and buy health insurance. And so this was the part of the law that helped to make it fair to insurance companies to even out the risk pool for all of society. So that's the theory behind it. Whether it's constitutional or not is up to the Supreme Court. And then the insurance affordability part, When setting in premium rates, health insurance companies, so what I said before, health insurance companies can't take into account anything really when they're saying whether or not they're going to insure you. But they can take these 4 things into account when deciding how much to charge you. And that's whether you're an individual or a family. Makes sense, right? How many people are we going to be insuring? Your age, so they can charge more the older you are. Your rating area, which essentially just means where you live, and whether or not you've used tobacco in the past or currently. So those are the only things they can take into account when establishing premium rates. They also, because they will be requiring health insurance for everybody, they're going to give out premium subsidies for incomes between 133% of the poverty line and 400%. And to give you an idea, 400% last year was about $90,000 for a family of 4 and about $43,000 for an individual. So if you make $43,000 or less as an individual, the federal government will give you money to buy health insurance, beginning in 2014. I think I'm almost out of time, so I can go. Do you want me to stop or keep on going? I have like 5 more slides. Okay. Sorry, we're fitting in a lot. So just very briefly, healthcare reform also changed Medicare and Medicaid. So the first thing it does for Medicare, and I think this is huge, and I had no idea that this was something. When you had Medicare before, Medicare is the health insurance for individuals 65 and older or who have been on SSDI for 2 years or longer. When you were on Medicare before, you got 1 wellness visit the first time you enrolled in Medicare. So you got 1 chance to see the doctor, just in a general checkup for a year, and then that was it. That was the only thing Medicare paid for the entire rest of your life. Now, they have to cover an annual wellness visit, so you can go to the doctor once a year for a general checkup on preventive services. That's not like if you have something wrong with you, you could go to the doctor and they would pay for it. But this was just a purely, I'm seeking preventive care. They also have to cover certain preventive services. Before, Medicare never covered any preventive services, and now they have to cover some. They also put the medical loss ratio at 85%, which essentially means that 85% of the money that is paid to Medicare paid for Medicare has to go towards, 85% of the premiums paid to Medicare Advantage plans has to go to care, not to administrative fees. It also freezes the premium levels, which essentially makes Medicare cheaper for some individuals. I can go into all of this in more detail, I'm just going quickly. It also closes the donut hole. If you had prescription drug coverage under Medicare, Medicare Part D, there was a big gap in coverage where you had to pay 100% of the coverage. If you don't know what I'm talking about, don't worry about it, but if you do, they're closing that gap in the law, and it will be completely closed by 2020. Healthcare reform is also expanding Medicaid. Now, this is a really big deal as well. This is another one of those that is huge, and also the Supreme Court is looking at the constitutionality of this. But to be eligible for Medicaid now, you have to have limited income and assets, but you also have to fit into another category. You either have to be age blind or disabled, which is where a lot of our callers fall in the disabled category for cancer, or you have to be pregnant or have children under 8. If you just have limited income, you're actually not eligible for Medicaid without having a second category that you fall under. So what healthcare reform did is it makes individuals with low incomes across the board eligible for Medicaid if you're 133% of the poverty line or below. So an individual who makes $15,000 or less will now be eligible. This is 2011 levels, so it'll raise probably, but it'll expand it to individuals at those low incomes. They don't have to show anything else before going on to Medi-Cal. And that's it. So I'll turn it over. Thank you.
Thank you, Anya. I don't know about you, but I'm out of breath. And I would have voted just for the single payer plan. You know, it would have been so simple. We just, have one thing. Do you all have a ticket? Because we do want to be part of the raffle. I want to mention a couple things, or re-mention things. Probably most importantly, I want to thank Millennium, which is part of Takeda Oncology Company, and they sponsored this program, paid for speakers, and very good dinner, I thought. So we thank them for that. We also want to mention, of course, your question and answers. We're going to collect those. And while we're doing that, we'll be doing some of the raffle tickets. Miriam was so overwhelmed, our organizer of our South Bay Cancer Survivorship Consortium, she was so overwhelmed in the middle of the talk, she went out and made 50 copies of the slides, so you do not have to wait to the end of the week. So thank you, Miriam. You know, you just overwhelm people with information, and sometimes you get what you want. So that's good. Now, the video of the program will be available in June, and I wanted to say also that the previous, I think the last two programs, we did a program actually almost a year ago with Carolyn Katzen on nutrition. That is still available, will be available on Torrance, tmmc.org. Oh, torrancememorial.org, thank you. You can see Carolyn Katzen, who spoke a year ago here about nutrition. And you can also see Carolyn Peterson, who talked about intimacy and sexuality for people affected by cancer. Her talk is online as well. And Anya's talk will be there. Anya will be able to see herself sometime in June. So that'll be fun. Our next program, which you might have seen on the first slides, but will be August 14th. It'll be a Tuesday evening. It'll be out about genetics. And we'll have a genetics counselor here and a cancer survivor to be speakers. And that will be sponsored by Myriad Genetics and their programs. So that's right. So let's see. Let's go to the raffle while we're collecting questions. I'll have Sarah pick the first ticket for the first prize. Okay. Now
Now you have to read it.
I have to get my glasses reading. All right, you ready out there? This is 681246. It's 681246. You have to be present to win. You're checking your pockets? Good. We may have a winner. She recognizes the number? No? Nope. Okay. 681246. All right, we'll pick another one. It's a red ticket. If you're holding a red ticket, you may be the winner. We have 021934. 021934.
Seriously.
This is the wrong group. It's in the other room, the winners. All right, 681231. We have found someone. Yes. Since you were the winner, you can pick the next one. All right, 786583. Oh, yes, we do have another person in the back. 786583.
Okay.
Come on up. Maybe another winner here, 681229. Yes. The prizes keep coming. perfect gift for a guy. Tools.
Oh.
We're down to one.
I don't know.
We have
Two?
a couple more. 853976. 853976. Yes, no? Oh, good. Chance for fame. Only one this time. It's a red ticket. 021993. 021993.
Ah, I got it.
Oh, yes. Okay, we're done? Thanks. Okay, so we're ready for the questions. And Anya has them. Great.
All right, so I'll go through these few questions, and then we can take more if there's time. So there's two questions here I can read through, but my answer is sort of, it depends, so I don't know how helpful it'll be. But one question is about short-term and long-term disability insurance. It's a private disability insurance. And then it's talking about eligibility requirements for the private disability insurance. And the other, well, so the question is about private disability insurance. And my answer to that is it depends what the eligibility is for that. So private disability insurance is not very highly regulated. So private health insurance is highly regulated, and the Social Security disability programs are highly regulated, but private disability insurance is not highly regulated at the state level or the federal level. And so those programs are going to depend on the contract of the policy. So it's really important to just read through the insurance policy to see what the eligibility requirements are and how that all works. That's an area where sometimes we match people up with an attorney if they're having an argument with the private disability insurance company for eligibility. So whoever asked that question, if it's something that you want to give us a call about, we can try to match you up if it comes to that, because it's basically arguing contract law. So unfortunately, there's not too much more I can say on that subject. And there's another question about that somebody who's a government employee on long-term disability coverage talking about early retirement options and how that affects health insurance. And that's also going to depend on the employer. So this would be true of any employer. Sometimes employees will offer early retirement or various programs. This happens at the federal level and in private level. And sometimes they'll give additional benefits. So they'll say, we'll pay for your health insurance coverage for 5 years if you go on early retirement now. Or we'll pay for health insurance through up to the point when you get on Medicare. So that's also going to depend. If it's a county employee, there might be a union involved. So that's a really good time to go and talk to a union representative. You can also, some of these specific questions, it's helpful to give us a call and we can talk through all of the specifics of it. But for Social Security, one of the main options for health insurance when you are retired is Medicare. And that kicks in when you turn 65. So as far as that goes, if you go on early retirement, that doesn't mean that you get Medicare sooner. You still have to wait until you're 65. So to the extent that the question was about health insurance options and Medicare, there's no early Medicare, unless you're on SSDI. Another question is, I'm currently under a Cobra plan. It will end December 2013. Would it be better to wait until January 2014 to shop for insurance since I have a pre-existing condition? So this is a really interesting question because it might be if health insurance reform continues to go on. So it could be that the Supreme Court says individual mandates are unconstitutional And so we can't have that portion. And if that happens, then Congress may scramble to rewrite the law to sort of even out the playing field, because as I mentioned, if you have the guaranteed insurance coverage, or there's not really a point to have the exchanges if you don't have guaranteed cover, if you don't have the individual mandate, there's not really a point to having the the coverage for individuals with pre-existing conditions. There's a point to it, but it might be difficult for insurance companies. So Congress may change the law if the Supreme Court does that. The answer is we don't really know. But let's say that the Supreme Court says it's all constitutional, we're going to keep the entire law, and assuming that the next Congress doesn't repeal any parts of the law, then 2014 may be a really good time to shop around for new insurance. What I would say is, because it's such a unclear field, always keep in mind that HIPAA is an option. So for this individual, they can go to 2013, end Cobra, and then apply for a HIPAA plan, which has been the law since 1995. It's probably not going to change. And so then you could get on a HIPAA plan, and while you're on that HIPAA plan, you can shop around for insurance on the exchange, and then get off of the HIPAA plan once you find a cheaper coverage through the exchange. So that way you kind of guarantee that continuity of coverage, because the last thing you would want to have happen is to have that gap in coverage for more than 63 days, have something happen with healthcare reform. Probably by like October 2013, we'll know a lot more, and so you might not have to make those decisions. But right now, it's unclear where the law is going to be. But HIPAA at least is an option, even without healthcare reform. Another question is, I make less than $20K a year. Would I be eligible for assistance for an insurance plan in 2014? So if we go back to premium subsidies, the answer is probably. One, for individuals who make less than $43,000, there will be premium subsidies available. So if you make $20K or under, or $40K or under, it's probably going to have some premium subsidies available. But the other thing is, because Medicaid is expanded, right now the income limit is $14,000, but depending on inflation rates, it probably won't get up to $20,000 within 2 years, but at that level, it might be worth checking whether or not in 2014 Medicaid would also be an option. So those would be some of the options for people. That's annual income, not assets. And Medicaid, and that's a good point, because Medicaid has income levels, but it also has asset levels. So if you have a 401k or a savings account, or 2 cars or anything like that, then that could count against you for asset levels. Any other questions? I'm happy to take them. Yeah, in the back.
I need some clarification about my health insurance options. I was single and under individual health insurance when I was diagnosed with ovarian cancer. Now I'm under my husband's plan, and he's planning to switch jobs, at which time there will be that 90 days lapse.
Mm-hmm.
And I'm planning to get a full-time job, which will I be covered under his plan?
So the question is, she's on her husband's plan, or her husband's employer-sponsored plan. He's considering switching jobs. So what, as a dependent, do you do when that's happening and you're not sure? She said she's thinking about getting her own job with employment. So how do you cover that? So that's an area where Cobra, you can go on Cobra if your husband switches a job and loses insurance through his employer, you both or just you could go on Cobra. And that is available. That's assuming that you have an employer with 20. He works for an employer with 20 or more employees. And you can do that, and you don't have to use the full 18 months. So you could just use 3 months until you get on the other plan. And that ensures that you don't have that gap in coverage, so that there's not a pre-existing condition exclusion period in the next spot. So I'm risk averse, so I would always say try any way you can to get that continuity of care. I think I had my health insurance overlap a day just to make sure I didn't add midnight wrong, but that's just my personality. You do have 63 days to work with. So if you're sure that you're going to have that coverage, then having that gap might be okay. But if it's going to be 90 days, or maybe there's something goes wrong and you don't have it, it's a personal choice what you want to do, but Cobra, it would be that option to keep some health insurance until you jumped on to the next plan.
If we can't afford Cobra, if I do still plan to search for a full-time job, would their insurance plan cover me, or would I get denied because of my pre-existing?
So the question is, if you don't do Cobra and you do have a gap, can a group health insurance deny an individual based on a pre-existing condition? The group health insurance coverage cannot deny based on a pre-existing condition, but they can impose the pre-existing condition exclusion period for, in California, up to 6 months. So if there's been a gap in coverage for longer than 63 days, you don't have that HIPAA protection of the creditable coverage getting rid of that exclusion period. So unfortunately, if you have even a 3-month gap, you could then, on top of that, have a 6-month exclusion period for a pre-existing condition. Although they cannot, a group health insurance plan can't say, we're not going to cover you at all.
So that exclusion plan meaning that I can't do CAT scans or ultrasounds or anything like
Yeah, if they chose to impose the exclusion period, and they would say what the pre-existing condition is, but let's say they said it's cancer, then if you got a cold or you broke your arm or something, then they would cover that. But if your pre-existing condition was cancer, they wouldn't cover anything associated with cancer, whether it was scans or chemo or treatment or anything like that. You had a question here?
You were talking about the EPD for the spouse or your caregiver. My wife has 2 jobs. She's gone away from one job to help take care of me. She still has her other job. Is she eligible to recover for lost wages from her other employment?
So the question is, under the Family Temporary Disability Insurance in California, a spouse has 2 different jobs and is taking time off one job to care for the individual and still has the second job. And that is an excellent question. I will have to look into that. The way the law is written is that it results in a loss of wages. So it could be that it's, well, there's no wages from this, so it should apply. On the flip side, it could be, well, you still have wages. So I would have to look, but I'm happy to do that. And so I'll get your information at the end. We can call you back. Yeah.
Could you talk a little bit more about the Medicare Advantage plan and what is that changing? Is it going away? What do
Of course.
we do to replace that?
Okay. So she asked, can I talk a little bit more about Medicare Advantage plans? So what Medicare Advantage plans are, to briefly talk about Medicare, Medicare has 4 different parts. And generally, Medicare covers 80% of costs, and the person is responsible for paying 20% of medical costs themselves. So there's a number of different ways to cover that extra 20%. Additionally, not all Medicare plans cover prescription drugs. You would have to add on Medicare Part D for prescription drugs. So what some individuals do is they enroll in what's called a Medicare Advantage plan. And this is essentially a private health insurance plan that's partially funded by Medicare that covers your hospital visits, your drugs, and generally has a higher coverage than the 80% that Medicare pays. So it's a more comprehensive plan. It's also more expensive than just straight Medicare. So that's how it is now. Under healthcare reform, there's been a lot of changes to Medicare Advantage plans. They still are an option, but they're more regulated on how much money they can spend on profit. So that's what I was talking about briefly. Oh. It's thinking. But that's what I was talking about briefly when I mentioned in 2014, Medicare Advantage plans are required to maintain an 85% medical loss ratio. So what that means is that 85% of the premiums that they get from individuals has to go towards caring for the individual as an actual cost of care. So 15% can be profit administrative costs. There's a lot of of discussion right now of what actually counts as paying for the cost of care. You know, is paying somebody to do the insurance bill, paying for the cost of care, or is that administrative? So there's a little bit of, you know, finagling around that. But generally, it's raising the bar of how much goes to consumers. Now that might change some of the way that the insurance works premium-wise, because they don't have quite as large of a gap for profit. So by decreasing the amount they can get, there might be a little bit. But we don't really know how that's going to work out. The other thing that they're changing is sort of, there's a little bit of cost changing for what they're calling Cadillac plans. You may have heard this. So some Medicare Advantage plans paid for gym memberships and massages and tanning salons, and it sort of were these really big, classy plans. And so those are being taxed a little bit more than sort of just your meat and potatoes Medicare Advantage plans. There are some other ones, and I'm just not as familiar with all the little ones, but if you want to give us a call or go to healthcare.gov is a really good resource for that. But we can also be happy to talk about more about the nitty-gritty. Any other questions? Great, well, thank you so much for coming. Oh, I'm so sorry. There was another question. Yeah.
I noticed on one of your slides about the CIP, it said that it's going to go away.
Yeah. So the question was for the pre-existing condition pre-existing condition insurance plan, the federal government, the PSIP plan. On the slide, it says that that plan is going to go away in 2014. And that is true because beginning in 2014, health insurance companies can no longer deny an individual based on a pre-existing condition. So the PSIP plans were just a stopgap measure until 2014 when you can buy health insurance on the regular market. So if you're on a PSIP plan, eventually they'll phase out. My assumption is that if the part, you know, if healthcare reform gets moved around, they may extend the PSIP plans, but we don't know.
Thank you
Okay,
very much.
yeah, thank you so much, everybody.
Yeah. Thank you for coming, and be sure and drop your evaluations off. If you want a copy of the slides, they'll be in the back. Thank you very much for coming. We'll see you in August.